Good afternoon, everyone. Thank you for joining the webinar today. I will get us started by going over the agenda. First up, we will have Mario Ayub from our Buffalo office. Mario is going to cover the EU AI Act and what US companies need to know. Next, we will have Candace Gomez. Candace is in our Long Island office, and she will be discussing the New York State school smartphone ban. And last but certainly not least, we will have Jim McGrath and Kamisha Parkins presenting on the Retail Worker Safety Act and what retailers should know to prepare. Okay, I will now turn the program over to Mario for his update. Mario?
Thanks, Carrie, and thanks everybody for spending your lunch hour with us. If you haven't heard me speak on the presentation on the Tuesday webinar before, I sit in our cybersecurity and data privacy practice and our artificial intelligence practice group as well. And I wanted to start today's program with a quick overview of the new EU AI Act that was passed last year and is starting to come into force portion by portion, piece by piece over the next couple of years. So it's a good time now to start thinking about your exposure to this act. And one of the things we wanted to emphasize today is even though this is an EU regulation, there are plenty of opportunities to bring US companies under its purview. So we need to start thinking through those issues now. Next slide, please. So just quickly, if you could go back one slide. So just a really quick overview of what we're going to talk about. I'll give a brief background on the act, what it covers, what it's designed to do, the scope and who it applies to, specifically with how it would apply to US and New York-based organizations, like many of you on the call today. We'll take a look at some recent guidance that was issued by the European Commission that clarified some aspects of this act. We'll talk through the Act's risk categories and how it categorizes each use of AI and how they fall into certain buckets of risk. We'll take a look at the implementation and enforcement timeline to give you guys a good idea of when obligations will start kicking in under this Act, and then some sector-specific risks depending on what industry you're from. There are some special considerations, and then finally some recommendations and best practices. Next slide, please. So enacted in August 2024, this is really the first time we've seen a comprehensive AI governance framework with international reach. This is very similar to when the GDPR first came on the scene. It was really the first comprehensive data privacy cybersecurity regulation that the world's ever seen. So we're expecting to see some other countries, including some US and US states. We're not sure on the federal side yet, but certainly some states are going to be looking at this act as a model for drafting their own legislation. So learning the ins and outs are important because we'll likely get a lot of these same requirements in New York, as well as other states that you might operate in. So it aims to ensure that AI systems are used in a trustworthy and safe way, with a special emphasis on the protection of fundamental human rights. We'll get into that a little bit more on what those rights are and how they interact with the act. But like I mentioned in the beginning, it implements a risk-based approach: minimal risk, limited, high, or unacceptable. And we'll walk through those briefly together today. Next slide, please. So very similar to the EU's GDPR, the AI Act has very, very broad reach. It'll apply, of course, to EU-based organizations, so any companies or entities that are founded or based and operate solely within the EU, but also non-EU organizations, including those in the US. And the tie-in for US businesses or US organizations is if these AI systems are made available to EU users, or the outputs from these AI tools are used within the EU, even if the actual AI tool or AI service is not available in the EU. So it's the availability of the tool or the product, along with whether the results or decisions informed by the model affect EU residents. So that's the common nexus there. Physical presence in the EU is not required, like I said, to trigger compliance. We really just need to look for how it touches consumers based in the EU. So for example, a New York-based company that's developed a software application or uses AI tools to make decisions based on EU resident data, that's going to fall under the Act's purview. Next slide, please, Kathy. So before we dig into some of the some of the main requirements. A couple of points worth noting in the European Commission's February 2025 guidance, where they've clarified some terms and definitions that weren't really clear from the face of the act itself. So further defining AI system, it's very broad. It could be a machine-based system, anything that has limited human involvement, operating with various levels of autonomy. Typically, we'll see a lot more scrutiny towards AI systems that don't require any human maintenance at all, but even systems that run automatically with some limited human input and controls will fall under this definition. So it's broad, and you can spend some time with the guidance, which is laid out in non-technical terms for entities who are looking to comply with this act. So I would definitely check out the guidance there. Next slide, please. The other area where they've clarified is what constitutes an unacceptable risk. Remember, we have this tiered-based approach that we're going to go through in a second, but unacceptable risk wasn't really defined in the act, which was kind of unhelpful if you're trying to determine your compliance obligations. So any AI tool that's really designed to manipulate or deceive, and so we could see those tools in the context of targeted advertising. Maybe they're collecting data and pushing ads on users that they didn't consent to. Exploitation of vulnerable populations. So any AI tools that interact with children or elderly, maybe where there's a technical knowledge gap there, that's going to be prohibited. Social scoring and surveillance, which we've already seen in some other countries starting to take shape in legal format, those are going to be outright banned. So this guidance will help steer your compliance efforts on what falls into this unacceptable risk category and making sure that the tools are not used for any of these purposes. Next slide, please. So we'll go through this quickly. If you want some more detailed information on this, we published an info memo that's available on Bond's website, so you can dig into these categories in a little bit more detail. But for the sake of time for today, because we have a packed schedule, we'll just run through it quickly. Unacceptable risk, we already mentioned from the EU's guidance what that might entail. Prohibited outright. High risk is the next tiered risk category, and this is going to be strictly regulated with some of the oversight mechanisms that are listed here. So it applies to AI in the context in industries and contexts where it might impact humans' individual rights. So if an AI tool is used to make an employment decision, to extend credit, if a bank uses it to determine someone's creditworthiness, critical infrastructure, any AI model that's used by law enforcement, maybe to predict recidivism or crime rates, those are going to be subject to very strict controls. So risk management, non-discrimination checks. So you're going to have to audit the tools used to make sure it's not discriminating against certain populations. There will be transparency requirements where regulators will expect you to be able to explain exactly how the tool manipulates data, and human oversight and documentation of risks that your organization is assuming by using these tools. So it requires an assessment in the beginning, justifying your use of something that might be considered high risk, and then ongoing monitoring and ongoing proof, basically, that you need this system and the benefits outweigh the risks that it would present to EU consumers. Next slide, please. Limited risk. So we're thinking about tools here that you're probably most familiar with. So chatbots, image editing tools, deepfake tools, so you could create very convincing representations of other people. I was surprised to see deepfake put in limited risk because I think we're going to see deepfake technology used for all sorts of different fraudulent purposes. So that might get changed as we start working with these issues with the act fully online. But it was surprising that some of these tools that can be used to deceive fell within these limited risk category. And then finally, minimal or no risk. Email spam filters, a lot of productivity apps that aren't necessarily making decisions on behalf of individuals. There are really no new compliance obligations here, except for things that would exist under existing law, like collecting consent to use a consumer's data within an AI environment. Next slide, please. So here is a high-level timeline of how the act is coming online slowly in pieces. And the key date to remember here is that August 2, 2027 deadline, where all general purpose AI models will have to be compliant with the act. It seems like a long way away, but we've been working with a lot of organizations who are really still trying to get their arms around, how their employees are using AI, how it's interacting with their customers' data or their own proprietary data. So although it does seem far off in the distance, there's plenty of back-end compliance work to be done in the meantime, which is why the Act provides for this longer on-ramp for compliance, because a lot of policies, decision-making structures, things of that nature need to be in place. And we'll talk very briefly about that towards the end. Next slide, please. So some sector-specific impacts to be aware of. Obviously, healthcare, a lot of these tools are going to be high risk because AI is already being adopted pretty broadly across the country and indeed the world for assisting with diagnostic imaging, assisting with generating treatment plans. So a lot of those high-risk controls, auditing for bias and fairness, justifying your use, making sure you can explain the technology, that's going to come into play in the healthcare sector frequently. Manufacturing is also now becoming very heavily reliant on AI processes. So here the organizations leveraging this technology in this sector is really going to need to be able to explain how AI is working with the data, technical standards that are either provided by the developer, or if your organization is developing something in-house, they need to be clear. They need to explain how everything's being used. Next slide, please. Financial services, again, I mentioned at the beginning, AI is now being used to make decisions based on credit applicants' creditworthiness. That's obviously going to introduce some issues pertaining to individuals' rights, purchasing power, ability to obtain credit. So again, we're going to be plenty of the Act's compliance terms are going to come into play here, auditing, explaining the use, making sure you're collecting consent where you need it from consumers. And then finally, education is another big area where this is going to impact US entities. Any ed tech companies that provide scoring or evaluation software, maybe your school district brings in some students periodically from Europe for experiential learning. We're going to have to be very mindful of the data that we are bringing from Europe and using with these tools, because that'll come with a lot of the Act's compliance obligations as well. Next slide, please. So finally, some recommendations and best practices. Again, we have some time to start bringing our systems in line with what the Act requires. It's also worth noting too that we're during this period of time between August 2027 and now, we're going to start seeing some US state-based laws starting to take shape too, and a lot of them are going to have a lot of the same accountability mechanisms built into these acts, consent. You'll start to see these themes repeat themselves across the jurisdictions that you work in. So not only are you preparing for the EU AI Act, but you're also preparing for some of the state guidance and state regulations that are going to start emerging throughout the US. So first, and obviously, inventory your AI tools. A lot of organizations really don't know what their employees are using, or they don't have controls over whether an employee can just access ChatGPT on their work device and spin out work product that way without you knowing. That's certainly an area of risk. Looking at the guidance to determine whether any of your uses might fall under unacceptable risk and seeing whether you can eliminate those processes. And then the back-end compliance work that needs to be done before you really start using these tools. Make sure you're collecting technical documentation from your vendors where you're licensing this AI software. Conduct risk assessments. Bond has helped shepherd many clients through the risk assessment process for bringing in new tech to be able to justify its use. Assign internal accountability. So who within your organization is going to be in charge of auditing or monitoring or checking quality of output. And that can flow through an AI governance framework that you set up as a formal policy where you will delegate roles and responsibilities to existing members within your organization to make sure use is appropriate. And then finally, a code of conduct or responsible use policy for your workforce generally that sets up guide rails on what you can and cannot use these tools for, which will help your organization stay within the bounds of the Act and other regulatory requirements to make sure that use is safe and legally authorized throughout. So that's all we have time for today. If anyone has any questions, please feel free to reach out to me. we can discuss any of these topics and more. We're helping clients right now with a lot of the preliminary steps on getting your framework off the ground for being able to use these tools. So certainly would be happy to assist and field any questions there. Thank you.
Thank you, Mario. We appreciate your overview and insight on the implications for U.S. companies. Next, we have Candace to discuss the New York State school smartphone ban. Candace, thanks for joining us today. I'm going to turn the program over to you.
Thank you so much, Carrie, and good afternoon, everyone. As Carrie mentioned, I will be speaking about the New York State school smartphone ban. You may recall that about a year ago, Governor Hochul started engaging in what she called a statewide listening tour. And by that, she meant that she was going to go to as many parts of the state as possible to meet with stakeholders, including administrators, teachers, students, parents, and advocates, to talk about the issue of smartphones. Because, of course, one of Governor Hochul's main concerns was youth mental health and well-being being impacted by the extensive and very widespread use of these smartphones, not only by students at home, but also in the school environment. And as a result of that listening tour, and after many deliberations with the New York State Legislature, Governor Hochul and the New York State Legislature recently reached an agreement on what has been called a bell-to-bell smartphone ban in schools. This new legislation takes effect for the 25-26 school year, and it amends the New York State education law. It applies to every public school district, charter school, and BOCES. And all of these entities are required to adopt an internet-enabled device policy by August 1st, 2025. And then, of course, the smartphone ban within the school buildings will take effect in the beginning of the 25-26 school year, which is September for most schools. When I say bell to bell, that term is very specific because it's meant to include the entirety of the school day. And as proposed in this law, the school day means all of the instructional parts of the day, including non-instructional time as well. So it's not limited to homeroom periods. It includes, I should say, homeroom periods, lunch, recess, study halls, passing time. So basically, from the time that the student enters the school building until the time that they leave, this smartphone ban is intended to be kept in place. I know that there was, various talk about, well, maybe students would be able to use their smartphones during their lunch periods, or maybe they could use it during a study hall when the teacher wasn't actively teaching them. And that is not the way that this legislature has, or this legislation has rolled out. It is truly a bell-to-bell ban in which students should not be using their smartphones. I would like to mention that this does not prohibit students from using other internet-enabled devices that are provided from the school for instructional purposes, such as laptops or tablets or other things that the school is designating as useful for the students' instruction during the school day. I would also like to mention that students will be allowed to carry what we call simple phones. These are phones that cannot access the internet, and these simple phones generally only allow a person to send text messages or to make phone calls, but any internet-enabled device phones are being prohibited pursuant to this bell-to-bell smartphone ban that is in place at this point in time. There are some exceptions for students who have particular circumstances, such as a student who may have a medical condition. For example, there are some students with diabetes who may need to track their blood glucose levels or other things using their smartphone, and there would be a carve out for students who need it for medical purposes. There's also students who have what we call IEPs, individualized education programs, that may need a smartphone for one reason or another, or students who need it for family caregiving or translation purposes. So there are some limited categories of exceptions to this rule, but I did want to make you aware of a few of those carve-outs. In terms of how these phones will be stored during the school day, that is something that is to be determined, meaning that schools will have to find a way to properly and safely store these phones during the school day. And that, of course, comes at a price tag because some of us may be thinking of what are called yonder pouches. These are magnetic locking pouches that a person could put their phone in, keep the phone with them throughout the school day, but they're not able to open that pouch or to use the phone until someone else unlocks it with that magnetic key. Good idea. And many schools, I'm sure, will choose to use it, but it's also quite expensive. It comes at a pretty high price tag when you're thinking about purchasing one of these pouches for each student in the school building. It is possible that there may be some types of discounts or reductions given by certain companies to schools that are purchasing it in bulk. And I'm sure schools will be in the process of exploring those opportunities. Governor Hochul has stated that she has secured $13.5 million in funding to be made available to schools that need assistance with purchasing these yonder pouches or other solutions. So we're, of course, looking to see when we will receive further information about how that money will be distributed to schools so that they can begin making some type of financial arrangements. So that pretty much covers the smartphone ban. I'm available for those who have questions. I should have introduced myself more thoroughly in the beginning. My name is Candace Gomez. I'm co-chair of the School Law Practice Group at Bond. Thank you all for your time, and I will turn it back over to Carrie.
Thank you, Candace. We really appreciate the update on this new legislation. I'm now going to turn things over to Jim and Kamisha, who will discuss the Retail Worker Safety Act.
Wonderful. Thank you, Carrie. This is Jim McGrath. I'm in New York City, and I think we should have actually called this program, Are You a Retailer? Because the way the New York law is written, it doesn't speak to retailers. It speaks to businesses that have 10 retail employees. Why don't we go to the first slide, Kamisha? So as we get into this law literally just took effect June 2nd. It applies throughout the state, and it's intended to provide a safe work environment for retail employees. Next slide, Kamisha. And here's the key. A covered employer is not a retailer. A covered employer is a business that has at least 10 retail employees. Next slide. So now you have to look at what is a retail employee. Well, a retail employee has to work at a retail store. That store sells consumer commodities. That, unfortunately, is not a term that is defined by the law, nor is it defined by any regulation. So you have to determine for your business, do you sell consumer commodities? Now, we have two easy exclusions. One is if you sell food for consumption on premises, you're not covered by this law. So that's restaurants, delis, that type of thing, where you're providing food that's being consumed on premises. It also doesn't apply to the state or any political subdivision of the state, public authorities, and so forth. Now, a retail store sells directly to the public at retail. Prior slide, Kamisha, if you can do that. There we go. Sorry, the next one now. There we are. So what this does, it applies primarily work at retail stores, meaning retail employees. But if you work at a retail store where there are at least 10 retail employees, then everyone in the store is covered. And the state tells us this by saying that if you're employed at a store as a cleaner, you mop the floors or polish the floors or whatever, you should be trained as well. And we'll get into that. So if you work at a covered store, then you are in fact going to have to be trained by your employer. Next slide. So what does the law require? It requires three things, really: a retail worker violence prevention policy, that is a written policy, and it also requires a training program. I'm going to talk about the policy, and Kamisha is going to talk about the training program. The third thing that is required, or at least recommended point, is video that the state has put out. Now, the good news is that both the policy, the training program, and now the video are available on the New York State Department of Labor's website. So what does the law require? Well, if you have at least 10 retail employees, then you're going to have biannual training. And then if you have more than 50, you have to have annual training. That is upon hire and biannually thereafter. Next slide. So the training policy itself you have to give a copy of your policy to each employee at the store. And you have to give a written copy of the training policy to those workers as well. Effective January 1 of 27, the really large retailers, those are with 500 or more retail employees in the state, are going to have to, or must have a silent response button that was initially called a panic button, but they renamed it. You've probably seen this tech. You can wear it on a lanyard, you can wear it on your hip, but that's going to be required of large retailers. Next slide, Commissioner. So the policy, as I said, if you have at least 10 retail employees, you can use the state's model policy, or you can develop your own. The state policy is free and it's there on the website. All you will need to do is to fill in your name and the name of a contact person at your location who is responsible for site safety. So it's pretty easy to comply. Many of you probably use the New York State model sexual harassment materials. It's somewhat like that. Next slide. The violence prevention policy itself, you have to list the factors that might place retail employees at risk. For example, late night work, when there are a few people in the store. You could have neighborhood factors where the store may be in a neighborhood that has higher crime than usual. You have to recite methods to prevent workplace violence, remedies available to victims of violence in the workplace, and so forth. One of the big provisions is this last provision, a non-retaliation provision. The state's materials spend a lot of time on you can't retaliate against an employee who complains about workplace safety. That was generally true under New York law in general. It's also true under federal law, under OSHA, if you're complaining about a specific OSHA workplace provision. But now this policy makes it particularly clear, and particularly clear for retailers. Next slide. As I said, it went into effect June 2nd. Why don't we keep going, Kamisha?
Oh,
Why don't you jump?
I'll take over.
Sorry.
No problem. So as Jim mentioned, covered employers under the Retail Worker Safety Act will be required to implement workplace violence prevention training within their workplaces. And this is effective June 2nd. Now, the state has created a model retail workplace violence prevention training program that employers may utilize, or they may establish their own training that meets or exceeds the minimum standards in this model training. So the model training, I want to emphasize, is twofold. Employers must have a written version of the training as well as an interactive component to the training, and I'll explain that in a few slides. Now, with respect to the written model training, it's important to note that it does not include store-specific information. But I do want to highlight that the model written workplace violence prevention training that the state has made available to employers, it includes 4 units, which note the requirements of the Retail Worker Safety Act for employees to be informed. It also explains de-escalation tactics and ways that employers may prepare for general emergencies that are likely to occur in a workplace environment, a retail environment specifically. And it also explains procedures that employers should take when there's an active shooter. So describing active shooter drills. And it is 14 pages long. I do want to make note of that as well. But all of the information that is in the model written training should be at a minimum in any written training materials that an employer utilizes, should they not decide to go with the state's model. So as I did mention, employers must add worksite specific and or company specific information in the training, and some examples of this are provided in the state's materials. It does note that a employer's worksite specific or company specific information should include at a minimum a worksite specific list of emergency exits or a floor map with emergency exits that are clearly marked, the location where staff should meet in the event of an emergency, instructions on emergency devices, such as fire alarms that are utilized in the workplace, including instructions on how they operate. Additionally, employers should include instructions on the security-related devices utilized in the workplace, such as personal response systems or panic alarms, with instructions on how they operate, as well as any other procedures that the state has not already listed in the model materials. Additionally, employers should include any history of security problems that has taken place at their store location and how they were addressed. So turning to the interactive component of the training, it is important that employers include information on the Retail Worker Safety Act requirements, examples of measures that retail employees can use to protect themselves when faced with workplace violence from customers, as well as other coworkers, some de-escalation tactics, active shooter drills, and emergency procedures. So I do want to mention that the model written workplace violence prevention training materials should mirror very closely with the interactive component. So it would essentially be a reiteration of what's already provided in any written materials. Additionally, the training should include instructions on security alarms, use panic buttons, and any other related emergency devices, as well as information addressing conduct by supervisors and any additional responsibilities for such supervisors. It should include training on areas of the history of security problems that should have been noted earlier in the training. And it should also include a site-specific list of emergency exits and meeting places in case of any emergency. Jim, you can.
Okay, let me address this. The video itself that New York State has provided, frankly, is exceptionally boring. You can quote me on that. The speaker sounds in some parts almost as if it's AI. Maybe Mario wants to look into that, but it is it's really quite boring. You have to watch it all in one sitting, so that's going to require you, the employer, to allow employees to take up to 30 minutes, 35 minutes or so to watch this training video. I have watched it. It is frankly complete common sense, really. I think you could pass the interactive questions having never watched the video itself. Why don't we look at the next slide? Okay, one of the things that is, here it is, the model training video. This is the preview. When you go to access the New York State training video, this is the screenshot you get. It's a little hard to see, but what it says is print your name, your first name, your last name, the name of your store name, and where it's located. So this was never discussed. It's not in the legislation. I don't recall it being discussed in any lead up to it, but effectively the employees are registering for this training. And more importantly, you, the employer, are being identified, at least in some fashion, as part of this process. Now, the state has said they want to do this to make sure that employees are in fact receiving the training, and employers, more importantly, employers are giving this training. So you should be aware. You should be aware of this. As I said, that was not discussed. We did have a question in the chat about services. Services per se are not covered by this legislation. You have to be selling commodities. If you're only selling services, then that's not something that is covered by the Retail Worker Safety Act, something that you should keep in mind. Before we conclude, something that has nothing to do with this topic, I'll tell you all that the jury duty pay in New York State increased to $72 from $40 effective June 8th. So I hope all of you are updating your policies accordingly. Employers are required to pay for the jury duty pay. That's $72 a day for the first 3 days. So that's just an added lunchtime benefit. And Carrie, I'll turn it back over to you.
Thanks, Jim. Thanks, Kamisha. And Jim, yeah, thank you for the update on the jury duty pay. I do a lot of handbook work myself, and I've been working that in, so I'm glad you thought to update the group. And thank you everyone for tuning into the webinar today. We have the contact information for all of today's presenters on the screen right here. Please feel free to contact any of them or myself with any questions. Gabe is going to be hosting the webinar next week on June 24th. For those of you that are interested, Gabe will be doing a wrap up to the end of the New York State legislative session. So please join Gabe if you're able to do so. Have a great rest of the day.